Oh, system on. Yeah, because I don't see the jail. There they go. There.
It's usually written on the potential you have order insurance. I noticed they have early.
Okay. All right, good morning, everyone. Welcome. I'm Judge Feld.
Hi, guys.
We are here for bond court. We're just here for me to tell you the charges against you, to see if I found probable cause, and to see if you're eligible to get out on bond. Today's not trial. You'll get to go to trial in front of your trial judge at a later date. So I'm going to call your name in the order that my clerk gives me your files. When you hear your name, you'll come up to the podium. We'll begin with Natalie Felician.
Judge, the victim husband is outside.
Okay. Yeah. Okay. How are you? I'm good. How are you? We're just waiting for her dad? Her
Husband.
Her husband, okay.
Victim. Slash husband.
Miss Felician, you can hear me?
Yes, ma'am.
Okay, your attorney is here. We're just waiting for your husband to come in the courtroom.
Yes. What is that? Oh, that's not. Can we bring him through that door, or is that not an issue? That's not
I don't think so.
Nope, okay.
I don't think that's how it works.
Not an option, okay.
Time frame as Station, right?
That's right here. Here she is right there. She's here to help.
All right, hang in. Count to 10. Take a breath. It's going to be okay. I'm Judge Feld. Okay, Miss Felician, you're charged with aggravated assault and battery, domestic violence. Your attorney's here and your husband's here. And Mr. Lewis, you want him to say anything?
Judge, he does. Judge Jim Lewis on behalf of Miss Felician. Judge, these folks, if I can speak for them, they've lived together for 10 years as husband and wife.
Yeah, just so you know, I did find probable cause.
I understand that,
Okay.
Judge. The most significant thing I do is they've been living together fine for the last 2 weeks. This event happened back on February 16, 2016. The police did not come. They came to her house yesterday and arrested her. They've been living together. They're fine. They've worked out their issues. He desires contact. If you read the probable cause, you can kind of understand what was going on there. But he loves her very much. He wants her to be able to come home. They have 2 small children. They don't have a lot of money, Judge. Their financial means are very limited. I'd ask the court to post a minimal monetary bond in the case and to allow them to have contact and to reside in the same residence.
They've been living together for like a year
Yes, Your
after
Honor.
the incident.
And Your Honor, based on what was presented by the counsel, state would be recommended standard bond on count 1, $1,000, and on count 2, $100.
Okay with that? Okay, that's what we'll do. Okay, she's going to be able to get out if you can postpone today.
And Your Honor, although they are living together, I would ask for no harmful contact.
I will send it. Okay, good luck to you.
All right. Thank you, Judge.
Thanks. Have a good weekend.
All right, ma'am.
Yeah, they live together. No harmful contact. Okay. Alberto Rojas Armando. Armando Alberto Rojas, sorry.
Good morning, Your Honor.
All right,
Come this way,
sir.
down
What
the
jail is he in?
Right now.
Main jail.
Okay, he's coming up. Okay.
You need an interpreter.
Luz. Hi. Swear her in. Luz. Luz. Right.
It's $1,000 count one, $100 count two.
Correct.
Good morning, Your Honor. Spanish interpreter
Hi.
present.
So with translate.
I will. Luz Angela Lopez, LPEZ, certified Spanish interpreter for the witness.
Okay, sir, you're charged with aggravated assault with a deadly weapon. I found probable cause, and your attorney is here, and we have an interpreter.
Señora Rojas, a usted lo han acusado de intento de agresión física con una arma mortífera sin la intención de asesinar o de matar. Tiene usted a su abogado aquí presente en la corte y la intérprete está asistiendo.
Oh, we're out of order because of the attorney. Sorry.
Good morning, Your Honor. Salvino Javier on his behalf. Judge, I reviewed the affidavit to arrest this morning. I also spoke to the prosecutor, and it's my understanding there was some kind of fugitive warrant. I can tell Your Honor, as an officer of the court, that right after this incident happened, I was retained in this case. I've met with Mr. Rojas multiple times in my office.
Counsel, may the interpreter interpret.
Okay.
Señor Rojas, su señor abogado de la defensa está aquí presente diciéndole a la señora juez que él revisó el affidavit de motivo fundado y que habló con el abogado fiscal y le informó que había alguna clase de orden de captura o algo así. Que como agente de la corte, perdón, counsel.
Judge, I made multiple inquiries to find out who was investigating the case, who the assigned officer was, so I can try and speak to them and surrender him. I had no such luck. He was arrested yesterday. I can tell you he's a U.S. citizen. He has a 2-year-old girl. He's been married for 7 years.
7 years?
7 years.
Married for how long?
For
Sorry?
7 years.
7 years. Señor, el abogado defensor le dice a la señora juez que él hizo un interrogatorio, preguntó a varias personas para averiguar acerca de su situación, no tuvo la suerte de encontrar a alguien que le respondiera a sus preguntas. Dice que usted es un ciudadano de los Estados Unidos, ha estado casado por 7 años, tiene una menor de edad de 7 años.
So, Judge, I would argue, of course, that he's not a flight risk. He's lived here for a very long time. He's got family here. We've got family here in the courtroom in the first 2 rows.
El señor abogado dice que la corte no debe preocuparse de que usted que haya riesgo de que usted se eluda la justicia, que usted hay familia aquí presente en la corte.
And just to illuminate what happened in this particular case, Judge, my client also lived in this address where the incident allegedly occurred. The alleged victim in this case is the ex-boyfriend of my client's new girlfriend who's seated here in the front row.
El señor abogado dice que para poder iluminar a la corte de lo que sucedió realmente, lo que sucede es que usted vive en la misma dirección donde vive la supuesta víctima, que es la exnovia, the ex-girlfriend.
The ex-boyfriend of this
Her ex-boyfriend is the
her
alleged victim.
ex-boyfriend.
La supuesta víctima es el exnovio,
Who's been stalking and harassing not only her, but my client for
que
months.
se ha mantenido acechando no solamente a mi cliente, sino también a ella.
To the point where my client's new girlfriend had to file an injunction against the alleged victim.
A tal punto que la nueva novia de mi cliente ha tenido que entablar o solicitar una orden de protección en contra de él por acecho.
And to top it all off, this alleged victim moved into their apartment building, which is where this happened.
Y para añadirle más problemática a este asunto, la supuesta víctima se mudó a ese edificio donde viven ustedes.
They want to speak?
No.
Okay.
And Judge, and at this point where this incident allegedly happened, the victim, 2 of his buddies, attempted to attack my client. My client defended himself, and even if you read the second page of the arrest affidavit, the victim starts running after my client in the car,
Señor,
Terminator 2 style,
La
with
se-
no fear
el señor
whatsoever
abogado le
after
está
being shot
diciendo
at.
a la señora juez que lo que sucede es que dos amigos de la supuesta víctima empezaron a correr y atacarlo a usted y usted tuvo que defenderse. Si usted mira el affidavit de detención.
So, Judge, I'm respectfully asking that the $100,000 bond that's currently set is excessively high. My client unfortunately cannot afford that. I think that a more reasonable bond in this case would be something in the range of $20,000 to $25,000, based on the fact that he is a U.S. citizen, that he has ties to the community, that he has a 2-year-old child here, that he has extended family. He's not going anywhere, especially after he's retained private counsel to resolve this case. It's an F3. This case is probably, in the worst case scenario, is going to result in some kind of probation.
Señor Rojas, el señor abogado defensor le dice a la señora juez que por estas razones imponerle una fianza de $100,000 realmente es excesiva. Usted no tiene los medios económicos para pagar tal fianza y que una fianza más razonable sería de más o menos $20,000 o $25,000. Usted es un ciudadano de los Estados Unidos, tiene vínculos con la comunidad, tiene una niña de 2 años de edad, tiene familia, bastante familia aquí. Usted no sería un riesgo de que se pudiera escapar.
And Judge, respectfully, I would disagree with counsel. I think Judge Singer had a chance to review the case in detail and signed a $100,000 bond. It's more appropriate.
In light of the allegations and the fact that another judge set the bond, this isn't a bond reduction hearing. You can make a motion for a bond reduction hearing with Judge Singer. But the bond is going to be stayed.
La señora juez la señora juez dice al señor abogado defensor que primero que todo la fiscal se dirige a la señora juez y le dice que ella no está de acuerdo con el señor abogado de la defensa porque ella ha revisado también el affidavit de motivo fundado y según esos alegatos y que hay otra juez que ha impuesto esa fianza. La señora juez dice que ella no puede cambiar esa orden que ya se ha puesto por la otra juez, que el señor abogado defensor aquí presente puede revisar eso y hablar con la señora juez Tobin-Singer.
Okay. ¿Comprendes, señor?
Sí.
Okay.
Yes.
Thank you, Your Honor.
Thank you.
Have a nice weekend.
Gracias,
Thank you, State.
señoría.
Thank you,
Thanks,
Judge.
Luz. Okay. Dana Potter.
Morning, Judge. How are you?
Good. How are you?
I'm
I
fine,
just need to find her. What jail? Okay, she's here. Okay.
Main jail.
Okay, got it. Thank you. All right, Ms. Potter, your attorney is here. I'm Judge Feld. You're charged with burglary and 2 counts of battery. I found probable cause.
Your Honor, I'd just like to say that this case is you can plainly see by the size of Ms. Potter that and the victims are substantially larger than her. She went over to her ex-boyfriend's house because she wanted to collect, among other things, her clothes and her keys to her car and some other things. And a fight ensued when he was invited into the home, and he wouldn't give any of the stuff back. So apparently there was some kind of altercation, and then the police were called, and then she's here on a no bond hold for a burglary charge, which is something that I rarely see unless there's somebody hospitalized. Nobody was actually hurt in this situation. Even taking the state's position to the maximum level here, it doesn't scream no bond hold in this particular case.
Okay. Mr. Corbin, you just want to state your name for the record?
Oh, I'm sorry.
Dana
Thomas
Potter.
Morse.
Oh, sorry.
Go ahead.
Judge, this is a punishable by life offense, the burglary with assault or battery. Since Your Honor has found and made a determination of probable cause, the defendant is to be held no bond if Your Honor would find proof evident presumption right.
Judge, you got a 2-sentence PC here on a no bond hold with somebody that wasn't even injured. It's no bond hold is insane for these kind of facts.
If counsel wants to set an author hearing before the trial judge, that would be more appropriate.
That's fine, but I tell you what, why don't you give her a bond in the meantime, and we can talk about bond conditions all you want at that point.
The
But
offense by itself requires that she be held no bond. It's proof. It's a punishable by life offense.
And true, and if you could have maybe even charged her with murder if you thought the Lindbergh baby was killed here too. But the point is that didn't happen, and clearly this PC doesn't rise to the fact that it should be a no bond hold. I just think in just reading the plain reading of it, it screams that she should get some sort of bond in this case, not be held on a no bond hold. My other issue is, well, first of all, she's lived here her entire life.
Is it because it's the burglary that makes it a life?
The burglary with assault or battery, Your Honor, it's a first-degree punishable by life offense.
It is. That's true. The charge itself, it does. But under these set of facts, please.
A finding of probable
What's
cause.
her priors?
Your Honor, I have 2 prior battery offenses that were no pros with different victims.
And his priors are extensive, by the way, Mr.
Well, that doesn't-
Rondino. I know, Judge.
That's not gonna,
First, another thing, she has her own catering business. She has a 2-year-old child that she had to make
no,
arrangements
I'm
with.
not disputing that. I just want to know legally if it's a punishable by life, is it
What?
automatically no bond?
Once you find probable cause, yes, Your Honor.
Judge, you can't possibly find probable cause in this affidavit with a one-sided story like this. I mean, they're a boyfriend and girlfriend. I mean, clearly there's some sort of invitee here. I mean,
Okay, well, that's going to come out of trial, but for now, we'll let the trial judge do that or do an Arthur hearing. So we're going to leave it as it is because of the charge, and I did find probable cause.
would you consider the fact that she's lived here her entire life and she's got a catering
I think
business
the
and
trial
2-year-old
judge
child?
will. I think the trial judge will.
All right, thank you.
Thank you. I didn't, but, yeah.
Ms. Potter. Ms. Potter.
Oh, I thought.
I'll try to get you in front of Judge Cohen right Monday, okay?
Okay.
And Your Honor, on count 2, it's a first-degree battery. Considering the allegations in the PC, state would be asking for a $10,000 bond on count 2.
Okay, I'm going to do 2,500 on that.
Thank you, Judge.
No contact, right?
When the court starts, we're done.
Okay. I'm going to call,
Ms. Potter, can you hear me? Can you hear me, Ms. Potter?
Yes.
I'll try to get
Yes.
you in court on Monday in front of Judge Cohen, okay?
Okay.
okay.
Thanks, Judge.
It is what it is. I'm sorry. Okay.
Ferrari just called, they have a violent, and they want you to call them out of turn if you'll
What's the name?
Ruben Altador.
Okay, then I'll call. Okay. Ruben Altador?
That's North Broward, Your Honor.
Okay, I just have to get his paperwork because I have, it's not, I don't have it.
Page is he on that? What? Page 15, Your Honor.
Okay, yeah, it's just, I don't have it like that. I have, what's his last name? Okay. Okay, Ruben? Okay. All right, so you're charged with aggravated battery on a law enforcement officer. I found probable cause. Okay. Okay.
From up north.
I got.
And Your Honor, I would argue that the great bodily harm includes the fracture and the severe injuries to the victim's
Yeah,
nose
no, I
and
found
right
probable
cheek.
cause on this one.
Judge, if I can take a look for a minute here.
Sure.
I was trying to figure out who was saying it.
That's a regular. Oh, the image. That'd be good. So he has a video.
Charge. I'm not going to do anything with it. I know they want us to charge these, but I don't know.
He broke his nose, he broke his cheek,
What's the charge? I would have to
Allegedly.
find out if someone to ask them to put on there that it's.
We're saying maybe the.
Does innocent work at this location or is it
Well,
You already said it. You already knew he already spotted. He did?
no, he
Okay. I disagree, so,
Your Honor, the state would be asking for a $7,500 bond and no victim.
yeah. Did you hear your counsel, sir?
No, ma'am.
Mr. Altador, can you hear me?
Yes.
Do you have a place to live?
Yes.
How long you lived in South Florida for?
20 years.
Okay. Do you have any kids?
Do you have
No.
any children?
Okay.
No.
Do you have any family in South Florida?
Yes.
Okay. Do you have a job?
No, sir.
Okay. Do you own any property?
Yes, sir.
What property?
I have a meteorite. The police confiscated. I was going to give it to the Pope.
Okay. Do you have a, have you ever been treated for a mental illness?
Yes, sir.
Okay. And do you have any money in the bank?
No.
Okay. Judge, I should be arguing $7,500 is tantamount to no bond for this individual.
Okay, priors?
Your Honor, that's the standard bond. One moment.
Put on there. So that they know what we're doing. And call down a term.
Your Honor, I have actually a pending charge against Mr. Altador in domestic violence. Judge Kathleen McHugh. It's a violation of a domestic violence injunction. There's a prior 2012 burglary of an unoccupied dwelling, grand theft in the third degree, both adjudicated. In 2010, burglary of a dwelling, grand theft with a firearm. In 2009, burglary, damage to property. 2009, attempted burglary of a structure. 2009.
Let's make it 10,000.
Your Honor, there's an order here I have that's been handed from Judge McHugh finding him incompetent to proceed, and the order also says the defendant shall be released immediately from the Broward County Jail. This is on, it looks like a different case number. It's a misdemeanor case number from Judge McHugh.
From when?
From February 23rd, 2017, based on 2 reports from Dr. Simons and Dr. Musgrove, finding that he was incompetent to proceed.
And I'm looking that up, Your Honor. Okay. Is that the criminal mischief misdemeanor?
I don't know what the charge is. I just have the case number. You want the case number, Camille?
Yes.
It's 1700-1158 MM10A.
How about we set the bond and have a mental health evaluation?
And Judge, I would recommend that, and I did find a prior 2009 first-degree murder charge.
Okay, we'll keep the bond and we'll do a mental health evaluation.
Judge, I would just object. The person was found incompetent to proceed. He cannot be held in custody like this.
And Judge, I would argue that that was a misdemeanor. I know that he can't be ordered on a misdemeanor to any facilities. However, the felony is different. The judge can actually order him to a mental health facility pending the outcome.
That's what we're going to do. He needs to be in mental health. The bond is 10.
Can we place him on pretrial release, Your Honor?
I would object to pretrial release.
Okay. Corbin Allen?
Let's go.
Hi, Mr. Allen. You are charged with domestic violence. I found probable cause. And who are you? Victim?
Yes, ma'am.
What do you want to say?
We had altercation.
Wait. Where's that noise coming from? Okay, never mind.
We had a misunderstanding. It wasn't as bad as it was portrayed, but him being in jail inconvenienced me. We have a 1-year-old together. My grandmother's funeral was today. I'm kind of running late, and I just want to try and get him a bond. It inconvenienced me with him being there. It stops me.
Yeah.
He doesn't have a bond. I can't go to work. I don't have a babysitter on the weekend. It inconvenienced me.
Judge, I'd be asking for a $100 standard bond, but I would be asking for no victim contact. I know the victim is here. Just because she's alleging she's not in danger does not mean she is not, in fact, in danger.
I mean, he...
I would require that she's even afraid of this individual. Because if not, then why order there be no contact between them?
He allegedly knocked you to the ground and was punching you like he was hitting a man.
That I didn't say that. Someone called the police. If he was punching me like he was hitting a man, I'm sorry to have my hat on, but not bruised or anything.
Well, at the time, they said your right eye was swollen and you had redness.
got poked in the eye during the altercation, but
Judge, this is domestic in nature.
I can show you a picture of my
Prior?
face yesterday.
You want his priors, you say?
Please.
2015 domestic violence and simple assault. 2014 burglary dwelling adjudication. 2006 violating an injunction against repeat violence. He violated his probation on that. 2004 aggravated assault with a firearm adjudication.
May I say something?
Does the court want me to continue? 2001 possession of marijuana. He failed to appear during the pendency of that case. Failed to appear during the aggravated assault with a firearm as well. Violation of probation on the charge of violating an injunction.
Sir, do you have a job?
Yes.
Where do you work?
I'm a labor for hire.
So are you working now?
Yes.
Okay. And how long have you been with that job?
Since July of last year.
Okay.
State was asking for a $100 bond, Your Honor, but no contact with the victim. But I defer to Your Honor.
I find probable cause.
Within the four corners of the probable cause.
Yeah. The state might have a hard time proving the case, but I find probable cause. Yeah, I'll give him pretrial release with a no contact order.
How do we?
I'm sorry for your loss too.
How do we do exchanging of our child? Do I go through his mother? Like we have a 1-year-old together.
Yeah. Yeah. The third part.
Standard, Your Honor.
Standard, no ankle monitor, but a third party will have to arrange for your child. Okay, good luck to you. Danielle Lewis?
Other than you, and then you go get the child. You can't be within 5 minutes.
Ms. Lewis,
Thank you, Judge.
All right. So.
Hello.
Hi, Miss Lewis, how are you? You're charged with domestic violence as well? Go ahead, counsel.
Judge, I'd be asking Your Honor not to find probable cause in this case. If Your Honor looks at the probable cause, the allegations support Ms. Lewis defending herself, and that the Dominique was the aggressor and the one that should have been arrested for a battery. She was recording him, and it looks like he touched her first, quite simply, by grabbing the phone that she was holding. That's the battery.
Judge, that's a self-defense argument for trial or maybe a motion to dismiss. It alleges that there was a touch or strike, which is all Your Honor needs to find,
Yeah, it's sufficient
against the will of
for
the victim.
probable cause for me. So, any priors?
Yes, Your Honor. No priors, Your Honor.
Okay, so pretrial release okay for you?
Yes, Your Honor.
No victim contact.
Ms. Lewis?
Yes.
Can you hear me? You're going to be
Yes,
placed
I
on.
can hear you.
You're going to be released. You don't have to post any. Is Your Honor an ROR, Ms. Lewis?
No objection, Your Honor.
I can't hear.
You're
I
going to
can't
be.
hear, I'm sorry.
You're going to be released, but you're going to be released on pretrial, so you have to be in contact with your pretrial officer. Okay.
And no victim contact.
And you're not allowed to contact. Yeah, Dominique.
What
okay?
about my kids? We have kids. Can I contact my kids then, because I'm the coach for their team?
Yeah, you could see your kids, but you can't see him.
Okay.
All right, good luck.
Thank you.
Yes, correct. Carlos Delgado?
Yes. Main jail.
Okay, sir, you're charged with violating an injunction for domestic violence, so it's no bond until you get to your trial judge, right?
Judge, I think.
Judge, no, he's in.
can set a
I'm sorry,
bond.
Judge. He's entitled to bond. I can tell the court that he's lived here for 10 years, that he has 2 children that are age 7 and 8, and he does have family members that live here in the area.
And Judge, he has no prior convictions.
Okay.
The state would be recommending a $500 bond.
Okay. So it'll
And
be
no victim contact.
$500 bond and no victim contact.
Thank you, Judge.
Thank you, Your Honor.
Thank you, good luck. Paul
You're welcome.
Giliberto?
Down the middle, outside. Coming up in the wheelchair.
He's on his way up, Judge. He's in a wheelchair.
Okay.
Judge, while he's on his way up, I can just tell the court that I did have a chance to speak to him. He's been here for 29 years, that he is married. He has no money in the bank. He's on disability right now. His wife is also disabled and in a wheelchair as well. Based on the nature of this, the fact that he's in a wheelchair and that, and he has trouble getting around, that, I didn't have a chance to read the probable cause affidavit. I know that the attorney in the courtroom did, but the victim in this case could have walked away. So I don't know. I don't understand how he was the one that got charged with it, because he, like I say, he's very immobile.
Well, you want me to read it to you?
You can.
Okay. It said that he arrived to the victim's home, banged on the front door repeatedly until the victim answered. The defendant then lunged towards the victim, kicking him in the knee, causing an abrasion to the victim's knee. The victim and the defendant are blood-related, they're brothers. The witness advised the following. She heard loud banging noises coming from the second floor, at which time she went downstairs and observed the defendant banging on the victim's front door. The victim could be heard screaming from the inside of the apartment, at which time the victim opened the door and the defendant then lunged towards the victim, causing him to fall to his knee, leaving an abrasion to the victim's knee. The defendant did intentionally kick the victim in the knee, causing him to receive an abrasion to the knee, and he's being charged with domestic battery, and subsequently was transported to the jail. Well, I can't hear.
Sorry, he's denying all of that.
Oh, I'm
I can
sure.
tell the court he's in a wheelchair, that he's very immobile at this point. So he.
Well, according
I
to
don't
the
know how-
affidavit, I find probable cause, but any priors?
Yes, Your Honor. There is a 2003 dealing in stolen property adjudication, a DUI from 2015.
You okay with pretrial?
Yes, Your Honor. No victim contact.
Okay, pretrial release, no victim contact.
Thank you very much, Judge.
Yes. Thank you. Willie Bowles?
Yes, that's...
Yeah. I mean, I took a few out of order with the attorneys, and then Corbin was out of order, this one that had the funeral. But now we're back.
What pages?
Oh, I don't know what page.
How you doing?
Willie Bowles, B-O-L-E-S. I'm just doing it in order of the way just the way they gave them to me.
I'm sorry, this is Willie Bowles?
Yes. Sir, you're charged with possession of cocaine and 2 counts of resisting an officer without violence and operating a car without a valid license. Just going to give your attorney some time to catch up. Get the paperwork. I guess it's out of order.
It's on page 19.
Okay. Maybe I got mixed up when I pulled the others. David Lane, is that out of order too? Right. Okay. He might have gotten stuck under the,
Judge, while they're looking that up, I can tell the court that he's lived here all of his life, that he is single, he has 3 children that are aged 14, 3, and 5, that he has no money in the bank right now, and he's currently not working, so he can't really afford any bond at this point.
All
We
right.
would just ask the court to consider pretrial release.
okay, I do find probable cause. Is there?
Your Honor, he has extensive priors. The state would be asking for you to keep $1,000 bond on count 1, on count 2, $100, on count 3, $100,
Oh, man.
Okay.
and
I'll
on count 4,
I'll just
ROR.
do the 1,000 on count 1 and no charge on 2 and 3 and ROR on 4.
I think you have to give a bond on 2 and 3 unless Your Honor wants the ROR.
Yeah, I'll ROR on 2, 3, and 4. So,
And I'm sorry, what was the bond on count 1?
1,000.
Okay, thank you, Judge.
All right. David Lane?
I had it off the table.
Good morning, Your Honor.
Good morning. How are you, sir?
All right, ma'am.
All right. So you're here because you have some papists outstanding.
And there is a bond on them, Your Honor.
Yeah, and the bond is already set on count 1 for 2,000, and it's an odd bond. It's $636 on count 2. So we're just going to keep those because they were already set. So you'll be in front of your trial judge soon, in a few days. All right, good luck.
Thank you, ma'am.
All right, good luck. Leering Benamara.
Judge, he indicated he's going to represent himself.
Okay, sir, you're charged with domestic violence.
Is there a chance?
Sir, yes, you're charged with domestic violence.
Yes.
Okay, and I found probable cause, and I'm just going to ask the state what kind of bond they're recommending.
Your Honor, he has no priors. State would be recommending a $100 bond.
You okay with pretrial?
Yes, Your Honor, and just no victim contact.
Okay, we're going to give you let you out on pretrial release,
And that's
and no victim contact.
ROR with standard pretrial release.
Correct. Okay, you're going to be out today. Good luck.
Thank you.
Okay. David Gunning.
Report to these people on Monday is right here. It shows you exactly where to go. Okay, Monday morning.
Hi, sir. How are you?
I'm alright. How you doing?
I'm good. Sir, you're charged with domestic violence and criminal mischief, and I did find probable cause. And state any priors?
Judge, there's only a juvenile prior, which I can't disclose. The state would be recommending a $500 bond on count 1. There's a $500 set for count 2.
Okay, and are you okay with pretrial release?
No objection to ROR with standard pretrial. I would ask for a no victim contact.
Okay, we'll do it for both counts.
Okay.
Okay, so yeah, with pretrial release and no victim contact. Okay. Now I can't hear anything. Luvensky Asami. Hi, sir. How are you?
I'm good.
All right, so you're charged with aggravated assault with a deadly weapon, battery, and criminal mischief. I did find probable cause, and I'm going to ask the state if you have any priors.
Yes, Your Honor. No prior convictions, only prior arrests. He does have a pending no valid license, which is traffic criminal.
Okay. And how long have you lived here, sir? In Florida?
4
4 years?
Yeah.
Where'd you live before?
Oakland Park.
Oh, okay.
Oh.
Yeah. So how long have you lived in Florida?
4 years.
Okay.
He speaks Creole, Judge, so
Does he
I don't know
need
if we
an
have a Creole
interpreter?
interpreter. It would probably be better.
Yeah, I think so too. So let's reset him for interpreter reset. We don't have one here, right?
No, Your Honor. It would be Monday.
Okay.
Judge, is there any way they could get an interpreter tomorrow? I mean, he's
I don't know.
sitting here.
There would be none available, Your Honor.
The court's informing me, the state's informing me that they're not available until Monday. And I'm not comfortable that he understands what's going on, so I'm going to reset it so he understands.
Judge, I would ask this of the court, then counts 1 and 2, except for a hearing, that's basically a no bond. In other words, he wouldn't be able to bond out. He'd have to sit here in jail and wait. And that's not fair because there's no interpreter here for him. So I would ask the court to set a bond for him or to ROR him to pretrial release. And, we could bring him back, on Monday if they wanted to. But it's unfair for him to sit here simply because he doesn't speak the language.
Your Honor, he would not be able to understand the bond conditions, if any, or an order of no victim contact, for instance. So if he were to be released and violate that order, we'd be in the same predicament.
I do, Judge, but it's unfair for him to have to sit here on a no bond hold for these charges.
Well, how is he
because
going to
we don't have an
understand what's happening? Who's going to explain it?
He can have somebody maybe explain it to him in the jail.
But
They could-
maybe. What if the maybe doesn't occur? What's going to happen?
I understand, but he's entitled to a bond, and basically what's happening is he's being held here 48 hours. I don't know why they stopped providing, and this is not with the court, but I don't know why they stopped providing Creole interpreters. They usually had one here before.
I hear you. It's like the ankle monitors. They ran out. I mean, that is
right. I would just argue that it's not right, that he should be entitled to at least attempt to bond out. At this point, he wouldn't even be able to bond out. So he's entitled to at least that right to attempt to post bond.
And he has priors or no?
Judge, I can look at his prior.
Well, I can't even ask him. I don't even know if he has ties to the community, if he works here, if he has family here.
Judge, I was able to speak to him. He understands some. I did take a little bit of time this morning to speak to him. He does live with his mom, he said. He's in 12th grade at Northeast High School. He's not currently working, and we were able to get that out of him this morning. So I don't know that, again, I don't know that he's a flight risk. He does live here. He lives with his mom, so his family is obviously here in the area.
Judge, there's no prior convictions. He does have a pending traffic criminal at the North Satellite. However, I would reaffirm our position that if Your Honor were to order no victim contact, he would not potentially be able to comply with Your Honor's order or any other conditions that Your Honor would place him on based on his misunderstanding of the English language.
But that's not a reason to hold him in jail.
Your Honor, if you want to reset it for tomorrow.
Yeah, but I could reset it, but what good is that going to get without an interpreter? Why would I do that? I'm not going to waste everyone's time with that. Let's do a $1,000 bond on each count with no victim contact.
Judge, could I also ask that this be reset for Monday so that they can address it so they can understand? And if the court would just note that the bonds were...
How did he note it? Well, how is he going to get back to court? How is he going to know he has to come to court Monday?
Well, if he bonds out, they'll just pass it by. But if he's still here, I don't want him to continue to sit here on a $1,000 bond if the bond should be lower than that. That's what I'm asking.
You're saying you need the hearing Monday if he's not out, if he doesn't bond out.
Correct. That's what I'm asking.
That's fine.
Thank you, Judge.
Especially said that would be good. Thank you. Dylan,
thank you very much.
Okay, Dylan Marsh. Hi, sir. How are you?
Good, ma'am. How are you?
I'm good. So you're charged with battery on a person over 65 years old and domestic violence?
And Judge, as to count one, I don't believe that there's any PC for the age, the 65 or older. I did speak with the officer who authored the PC, and he agreed that there was no intent for that. So state would be just recommending Your Honor find PC on count 2 with a $500 bond.
Okay. All right, so are you null processing one or lowering the charges or?
Yeah, I just don't find PC. I guess Your Honor could just not find PC on it.
All right. So we won't find probable cause on count 1, but I do on count 2. And do you live here? How long have you lived here?
Half my life, sir. All right, ma'am.
Okay. And do you work?
Yeah.
Where do you work?
I install fence for a living.
Okay. So $500 bond is fine. Yeah. No PC on one.
And if you go to a
Christopher Whitehall. No, this isn't, an out-of-state hold. Felony, so.
James Capers?
White Hill, not White Hall.
Gotcha.
Whitehill. Mr. Whitehill?
James.
Yes, ma'am.
Okay, sir, you're here on an out-of-state felony hold. It's a no bond. You're going to be in front of your trial judge in a few days. Okay?
That's extradition hold.
Yeah, it's actually an extradition hold, Judge.
Okay.
You'll go probably Monday. You'll go to the extradition judge.
All right. Good luck. All right, Tracy Lauren. Hi. You are here on a warrant that's already, the bond has been set at $500, so we're going to leave that bond.
Judge, she wanted to know if the court would consider working the case out today at a time served.
Her bond was posted.
Oh, okay.
It was.
There you go.
Thank you.
Okay.
Thank you, Judge.
Thanks, clerk. Andrea Laura.
North Broward.
That's a medical reset, Your Honor.
Okay. I signed it. Andrea Laura.
Judge, there's one more domestic violence that they pulled.
Okay. Do you have the name?
Yeah.
I believe the clerk just handed it to you.
Oh, yeah, I have it. Oh. Okay. Michael Smith? So this is the only paperwork I have on it?
Go down the middle, sir.
Yeah.
Is it in the main jail?
Yes, he is. He's on his way up.
Okay.
Date of birth. Yeah. 2865.
Okay. All right, you're charged with aggravated battery on a pregnant woman and neglect of a child without great bodily harm. I found probable cause, and I'm going to ask the state for their recommendation and priors.
Your Honor, I do see a prior ag bat on a pregnant individual. I'm confirming the victim. The victim was the same as the victim in this case. It's 2015. It looks like the date of incident was from November. I see a prior traffic criminal from 2002, no valid DL, and then just this case. But based on the fact that this is the second offense against this victim, Your Honor, state would be asking for a $10,000 bond on count 1 and a $5,000 bond on count 2.
All right, sir, do you live here? How long have you lived here?
For 20+ years.
You work?
Disability.
You're on disability? Okay. It's going to be $50,000 on count 1, and what did you want on 2?
$5,000.
$5,000 on count 2.
Judge, I know that he won't be able to afford that. He does have some money in the bank. Would the court consider lowering the bond to $7,500 on count 1?
No, but you could do a motion for bond reduction in front of his trial judge.
And I would ask for no victim contact.
Yeah, no victim contact.
Any mental health issues?
5,000. Okay. Antonio Russo? No victim contact. Yeah. How are you? I can't hear. Can't hear.
Oh, sorry.
That's okay. How are you?
I'm good. How are you?
Okay. You are charged with burglary. Did find probable cause, and I'm going to ask if any priors.
Yes, Your Honor. There was a prior 2015 burglary of a conveyance. It was a withheld adjudication. There were juvenile priors similar in nature.
Okay. And do you work here?
I don't have a job right now. I'm just in high school.
You're in school? Okay.
Oh, yeah.
And how long have you lived here? You live with your parents?
With my grandma, 19 years.
And where are your parents?
My mom's in jail, and my dad, I don't
no.
really.
No, your mom's not in jail. She's right. Are you grandma? Okay. Oh, your grandma's here. Is that
Yes,
your
ma'am.
sister? Her sister?
Yes, ma'am.
Oh, and your sister's here. Okay. You want to come up? Okay. So, what's your recommendation, State?
State would be recommend the standard bond, $2,500.
Okay.
And no return to that location.
Okay. And are you going to be able to post that bond?
I will have to. get it
Okay.
somewhere.
Then we'll do $2,500 and no return to the location alleged in the PC. Okay. All right. Your grandma's going to post your bond today. Hopefully. Good luck. All right.
Thank you, Judge.
Ben and Marie Harris.
North Broward.
North Broward.
Hi, Miss Harris. How are you?
Fine. How are you, young lady?
I'm good. You have 2 violations of probation for felonies, so.
And there are no bonds,
There are
Your
no
Honor.
bonds. So you're going to be in front of your trial judge soon, okay?
Yes, ma'am.
All right. Good luck.
Thank you.
All right. I'm sorry. 2,500. No victim. No return. Is there 2? Okay. Lakeisha Beckford.
They have her name. Oh, bonded.
Okay.
Is Your Honor finding PC?
Gail White.
On Judge
Main jail.
Lakeisha Beckford. Do you
Good morning.
still have to make a determination of PC?
To bond. Hi, Miss White. How are you?
Good morning.
All right. Good morning. You are charged with battery of a person over 65 years
Thank you.
old. You okay with the PC in this one, State?
Yes, Your Honor.
Yes, so am I. The age is in there.
Yes, Your Honor.
So, priors?
Yes, Your Honor, she did have extensive priors.
How long have you lived here, ma'am?
45 years.
And do you have a job?
Yes, I work at the Ramada.
Okay. How long have you been there?
Almost a year next month.
Okay.
Judge, she has a pending secondary felony pending here in Broward County, felony in possession of a firearm and ag assault. Your Honor could have a finding that while on a pretrial release, she did violate by committing a new offense and hold her no bond. She also has.
I'm not on pretrial.
While on pretrial release status, Your Honor. And also, she has a possession of cocaine in 2014 that she was adjudicated on, an ag bat on a 65-year-old or older in 2008 that she was adjudicated on, burglary of a dwelling of an occupied structure in 2008 adjudication, prostitution in 2007 adjudicated, unlawful use of false name adjudicated in 2007, criminal mischief in 2007. There were some other prior arrests, but not convictions as well. So based on her prior history, the fact that she does have a pending case here, I would be recommending $10,000 bond if Your Honor wants to set a bond.
That's what I was going to do. That's what I was. Okay. So $10,000.
Judge,
$10,000 bond.
I would just indicate she's unable to afford that amount of bond. She's while she's working now, and she's been working for a year. She doesn't have that kind of money. I don't know if the court would consider something less.
No, but maybe
Please.
the trial judge would. Thank you. Samantha
Thank you,
Carrera.
Bond.
This is a felony.
Oh, bonded. I'm sorry.
Yes, Your Honor, it's already set.
I signed it.
She bonded, Judge.
Oh, Meryl Delman.
That's still Broward, Your Honor.
Hi, Miss Delman. How are you?
Hey, how are you?
Yeah, that's what you said. All right, that's okay. You're charged with larceny, $300 less, $10,000 from a person over 65 years old, dealing in stolen property, and pawning the items. But your attorney's going to make an argument here about the affidavit.
Judge, I don't believe there's probable cause for the count 2, the dealing in stolen property. The rings were her grandmother's. It doesn't appear that she's engaged in an organized scheme of, is a part of some group of fencers. She's what appears to be at the most a common thief, which is dealing in stolen property is a statute that's supposed to cover people who are engaged in like a criminal enterprise of stealing and selling stolen property, not someone who just takes something from their grandma and pawns it. This is this is a theft case, and false verification for a pawn owner, but not dealing in stolen property. She's not engaged in some criminal enterprise.
And Your Honor, I did pull up the jury instructions on the offense, and the first element is that the defendant trafficked in or endeavored to traffic in, so I would agree with counsel that
Okay, so
there's
we'll
no
find
PC
it on
for
count 1 and 3 and not on count 2.
Thank you, Your Honor.
Okay, and leave the bond at $1,000 and $3,500?
Yes, Your Honor, state has no objection.
Okay. All right. Right. Okay, so your bond is $1,000 on count 1 and $3,500 on count 2. Good luck. I mean on count 3.
Count 3. Thank you.
All right, Camilla Rose.
Ms. Rose is at the Paul Ryan facility, Your Honor.
Your Honor, if I can approach with the original PC, I don't know if Your Honor has it on this one.
All right, you're charged with robbery. From what? Or to what?
It was changed from a robbery by sudden snatching without firearm to a robbery without firearm or weapon, a second-degree offense. Second-degree felony.
All right, I find probable cause for this.
And state would be recommending a $5,000 bond.
Okay, do you have, does she have priors?
Yes, Your Honor.
What are they?
Well, let's say it looks for priors. So the charge now is just regular robbery?
Right, without a firearm.
if someone, I'm just reading the PC now, but where is there, where Ms. Rose is, an affirmative allegation that says Ms. Rose is putting the alleged victim in fear or using force or the threat of force or violence against the victim?
One moment, Your Honor.
This is a sudden snatching, not a...
No, it's a robbery without firearm, without the setting snatching.
Yes, I would think that the allegations, if they support anything, they do support sudden snatching, but not robbery without a weapon.
One moment. Your Honor, the prior, I'll go into the priors first. 2012 criminal attempt, second-degree felon.
Wait. What's the charge?
The charge as to what we're here finding PC on, robbery without a firearm or weapon.
Okay, so you changed it from robbery by sudden snatching to plain robbery?
Yes, Your Honor.
Okay.
And she has a 2012 criminal attempt, second-degree felony, adjudicated on 2 counts. And that are all the convictions in the state of Florida. I don't know if she has anything outside of the state of Florida as far as the PC. And counsel, if you can reiterate, what were you saying about the robbery?
I was saying that there doesn't seem to be any affirmative allegation that she was using any force or threat of force or violence.
Pushed her from behind, causing her to fall to the knee, suffering pain. Allegedly.
And Your Honor, it does indicate also that post Miranda, she admitted to the robbery.
Yeah. Now I find probable cause. And what were the felonies for?
The priors?
Yeah.
It was criminal attempt, second-degree felon.
Criminal attempt what?
I can look more into... It's an arrest from 2010, Your Honor, so I don't have the probable cause affidavit.
So what's your recommendation for bond?
$5,000, Your Honor.
Okay, that sounds reasonable. Okay, you have a $5,000 bond. Good luck.
Okay, Your Honor. Thank you.
You could have a seat. Jason Gore? Oh, no, I'm sorry. That was out of order. All right, sorry, guys. Hi, Mr. Gore. You're charged with DUI. What's your recommendation state?
Judge, I think that one's out of my order.
Yeah, it is out of order.
Okay, one moment.
It's about maybe 10 cases down.
Yeah.
Page 13.
Oh. Judge, the bond amount of $1,000, I'm looking and I don't see any priors here in Broward County.
All right, you live here, sir? How long have you lived here?
About 40 years for
Okay,
college.
and you working?
Yes, ma'am.
I'm sorry?
Yes, ma'am.
Okay, and where do you work?
I work for Uber.
Okay, well, it gets it too. Poor Uber. Okay. All right, we'll leave it at 1,000.
And Your Honor's finding PC.
I can't afford it.
Judge, would the court consider a lower bond? He indicated he couldn't afford it, and he probably won't be able to work at this point for at least some time.
That's okay. I'm good with it. Thanks.
Thank you, Judge.
All right, Carla Ordonez.
That's no problem, Your Honor.
Okay. All right, Miss Ordonez, how are you?
Doing okay, ma'am.
Okay, you're charged with possession of fentanyl, possession of cannabis, and drug paraphernalia. I did find probable cause. You live in the community? You live in Florida?
Yes, ma'am.
For how long?
I live in Margate. I don't live in North Lauderdale anymore.
Okay, how long have you lived in South Florida?
Since I was 8 years old and I'm 43.
Okay, and are you working here?
I was working. I'm not anymore right now.
Okay.
Trying to get myself together.
Okay, any other criminal charges?
Your Honor, she has a 2006 ag assault on a law enforcement officer and a 2006 misdemeanor battery and possession of cannabis here in Broward County.
Okay.
Ma'am, I did not do any, I did not assault anybody.
All right, don't
Don't
say
say
anything
anything.
about the facts of your case because we're on the record. So if you have any defenses or anything, you need to discuss that with the attorney just in case you want to go to trial. The other side won't know what you're going to say, okay? I don't want you to say anything that could hurt your case later. So I'm okay with $500 bond on count 1 and ROR on 2 and 3.
No objections, Your Honor.
Okay. All right. Good luck to you. Emily
Thank you.
Peckman.
Reset. Your Honor, she's a medical reset.
Okay. Roy Range.
Main jail.
Hi, sir. How are you? All right. You're charged with trespass. I find probable cause. You okay with ROR?
Yes, Your Honor.
Okay,
No
we're going
objection.
to ROR.
Okay, you'll be out today. You have to come back to court.
Do you know who you're here for? Who are you here for?
Okay.
Oh, you're the defendant? What's your name?
You going home, man?
Yes.
All right. Shem Sherrod.
North Broward.
Right where you were.
Yeah, this is the one.
Yes.
If we could turn that noise on. Thanks.
You're like this, turn it on. Like, no, I didn't.
Okay, and your argument?
Good morning, Your Honor.
Good morning.
Just off of my memory, I believe it doesn't actually say anywhere there's an affirmative allegation that he was warned.
You remain uninvited until the security entered the building the next morning when they found him sleeping on the ground.
But I think the statute says that he has to be told to leave and then he refuses to leave. Because if you look, the PC is, well, first of all, for trespass, he has to be warned. But that as well. If you look at that probable cause affidavit, I believe this is the one where the officer crossed out trespass, failed to leave property, and hand wrote something else in. But I'm still trying to find the probable cause
He
affidavit.
crossed out after warning. He just, maybe failing to leave the property is the charge now?
And Your Honor, I'm looking up the statute because I do believe there is a general trespass statute that does not require prior warning, but his
Yeah, well, he
his
took out
intent
the
to
warning.
remain. Yeah. Enter upon or remain in a property other than the structure, which he did, and that he was not in possession, lawful possession, and that
I'm gonna
he,
find
without
probable cause.
authorization.
But I'm gonna ROR.
No objection to ROR.
All right. You're gonna be able to go out today, sir.
I'm able to leave today?
Yes.
Thank
All right, good luck.
Thank you.
Barrington Devereaux. This is an MO.
Main jail. Judge, this is a municipal
Yeah.
ordinance case. That there is nobody here from either the defense. We don't represent them, nor is there anybody here from the prosecuting office. I would ask the court to consider dropping the case since there's nobody here to represent him or to represent against him. In the alternative, I would ask the court at a minimum to ROR him.
Yeah, I'll ROR him. I'll find probable cause. Okay, thanks.
Okay. I'll be out
Lonnie
today. No problem.
Passaic,
Much further.
same thing.
Same, yeah.
Okay, so we'll find probable cause, but ROR.
You'll be out today.
Okay. David Tyner.
Right here.
Yeah, third line.
Hi, sir.
Good morning.
You're charged with drug paraphernalia, disorderly conduct, and trespassing. I found probable cause. You okay with ROR on all counts, Dave?
No, Your Honor, based on his priors, he does have 5 prior trespass stemming from 2010 to 2014. State would be recommending a bond in the amount of $500.
You have a place to live?
No, ma'am.
Okay.
I'm currently homeless.
Okay, you're gonna ROR. On all counts.
Thank you, ma'am.
Okay, good luck. David Carroll?
Carol. Carol. You, man.
He's on his way up.
All right.
I'm deaf, so you gotta choose.
Okay. Judge, he indicated that he's hard of hearing, so I'll interpret or
Okay.
explain it to him.
All right, thank you. Sir, you're charged with trespassing?
You're charged with trespassing. Charged with trespassing?
Yeah.
Okay. I did find probable cause.
The judge finds probable cause to detain.
And do you have a place to live?
Do you have anywhere to live?
What?
Where do you live?
Are you homeless? He's homeless, Judge.
Okay, we'll ROR.
Okay, you'll be out today. She's gonna ROR you. She's gonna ROR you. You'll be out today. If the state files, you have to come back. Okay?
Okay. Thank you, Judge.
All right, thank you. Ryan Lewis?
How you doing, sir?
Good morning, Judge.
All right, good morning, sir. You already have 2 warrants out that the bond has already been posted, set for $1,000 each, so we're going to keep that in effect. You'll see a trial judge soon unless you bond out. On the 8th. Diagnes Abad?
Robert Clark?
Mr. Abad?
He's on his way up.
Okay.
Oh.
Abad, do you have him?
Abad?
Yeah.
1 second, Judge.
Okay.
Oh, he bonded.
Okay. Teal Miracini?
The other case? Okay, good.
That's North Broward, Your Honor. He's coming in. You
Okay.
can stay in a wheelchair. She can say, sit down, sit down, sit down. She'll push you in. She can sit down. Come on. There you go. Look at that. She can see you there. You don't have to stand up.
All right, sir. You can see me? You can hear me?
Yes, ma'am.
Okay. You're charged with disorderly conduct, intoxication in a public place, battery, and trespassing. And I did find probable cause and ROR on counts 1 and 3.
No objection, Your Honor.
And on count 2 as well? Well, no,
Judge-
not count 2. I'm sorry.
On count 2, I'd recommend the $1,000 bond and no victim contact.
Okay. And we'll do that. We'll keep the 1,000 and no victim contact on count 2. Yes.
Your Honor.
Well, don't
I like
tell me
to plead
about.
guilty.
Listen, I don't want you to tell me anything about the facts of your case.
No,
Just because I don't want you to say anything that could hurt you at a later time if you go to trial on this.
I want to plead guilty, that's all.
Okay. We're gonna set you in front of your trial judge. You can plea out there.
I got no bond, though.
No, a
No way to
$1,000
make
bond.
I don't have money.
Okay, you're gonna go in front of your trial judge.
I don't have no money, that's why I want to plead guilty.
Okay, I'm gonna let you do it in front of your trial judge.
2 new charges.
Okay,
One
sir. Artrell Ford?
Judge, if I can approach with some paperwork on Mr. Ford.
Hi, Mr. Ford, how are you?
How you doing, Honor?
All right, I'm good. You have 2 counts 2 and 3 of a felony capias.
Your Honor, this was a ad charge, and I have provided Your Honor and counsel with a prior order holding the defendant no bond by the magistrate judge, Judge Davis. I've also provided you with a PC as to the original as charged. So the state would be asking that Your Honor order hold him no bond, as this is a punishable by life offense.
Judge, there's been no motion for pretrial detention. No one's here at this time to testify that proof is evident or presumption is great. There's been no finding that proof is evident or presumption is great.
I'm gonna read it right now, so.
And, yeah.
Judge, we would ask that you not find proof, evident, presumption great. It's a much higher burden even than reasonable doubt. A probable cause affidavit is not sufficient to prove proof, evident, presumption great.
Okay, well,
because the
this
burden is so high.
This is for the robbery with a firearm. You're adding this charge?
Your
In
Honor,
addition to the other 2 counts?
actually, it was only, and I need to clarify, the ad charge is to add 2 additional victims. So if Your Honor would look, Judge Davis has already found probable cause on the robbery of a firearm to a 3rd victim.
Okay.
So Your Honor is finding probable cause to 2 additional victims that were not originally charged. And if you look at the PC,
So this is the new PC that includes the other victims?
actually, the PC that I handed Your Honor and counsel was the original PC.
Okay.
What that Judge Davis found probable cause
Okay.
on, but on that PC, it was only probable cause to 1 victim. And as you can see, the 3rd line of the PC, it lists 3 different victims. Hector, Guerrera, Alex Padilla, and Wilmer Hernandez. So the ad charge is only for the 2 additional victims that weren't originally charged. And because Judge Davis already made a probable cause finding and is the defendant.
Where do you see how many victims he has?
This,
And Judge Fine already set no bond on 2 felony capiases. Okay, so Judge Davis found for 2 victims? But where does it say 1? 1 female? Okay. Well, see, I have 2 and 3 as previous felonies.
Yeah, it's just a change of charge previous when we add charge. The
Okay,
defendant,
so,
it shows
okay.
as a habeas.
Okay.
So it's the same crime, it's just 2 additional victims. So he's been charged with 2 additional counts.
So this is not the PC that Judge Davis read? Or it is, and for some reason he didn't find for the other victim?
We didn't charge.
Oh, you didn't charge it?
Yes.
Why not?
At the time, it just was not charged, so we did a change of charge to add the 2 additional victims.
At the time of arrest, Your Honor, the officer only wrote 1 count on PC, so the jail cannot add charge.
No, not the jail, the officer.
That's what I'm saying, we can't add charge from the bench. If he found probable cause for 3 victims, the officer only put 1 charge. So the state has to go back and add charge it, and that's why we're here today.
Okay.
To add charge on the 2 victims.
So that's what we'll do. I do find the same thing as Judge Davis, so I do find proof of evidence or presumption grade exists, so.
To hold him no.
We would be objecting to that, Your Honor. There's been, when it's testified, just a probable cause affidavit's not sufficient for that burden. It's,
Trevorrow Finley?
And Judge, we have the same predicament. I pulled it up on Odyssey. He is represented by private counsel, Mr. Weinstein, I believe, and I'll just confirm that for the record. But he does have an author hearing set on April 18th of 2017. He's already being held no bond, and it's just the additional victims that Your Honor needs to find PC on.
And who are you? Okay, what's your name?
And one moment.
represented by private counsel in this case?
Yes, I do believe so. I'm going to pull it up. I believe his name is Mr. Weinstein.
Is it Michael?
I think so, Your Honor. I just want to
Do you have
clarify.
a phone number for him?
I will. Your Honor, actually, right now it's showing the public defender's office.
Okay.
But the ASA, who's generally in magistrate court, has indicated to me that I can indicate to Your Honor he does have private counsel, and I'm looking at Odyssey right now, Your Honor, on case number 17001236. CF10A in front of Judge Fine. He's set for an author hearing on April 18th of 2017. And there was a writ of arrest for the original robbery with firearm on the one count, and we've charged 2 counts for 2
Okay.
additional victims.
And you have your counsel's phone number?
Yes, ma'am.
And it's Michael Weinstein?
Yes, ma'am.
Okay, what's his number? Oh, no, just tell it to me. I'll call him from the bench.
Okay.
Oh, okay, you're looking it up.
Judge, if you could also just ask her if she actually gave him money and retained him.
954.
Okay.
761. 1420.
Did you pay him?
Yes, ma'am.
Okay. She said yes.
Thank you.
And what's your name again?
Brenda.
Brenda what?
Willis.
Michael Weinstein.
Hi, Mr. Weinstein. It's Judge Feld. How are you?
How are you?
I'm good. We're on the record. I'm in bond court with your client, Trevorrow Finley.
Yeah, I'm well aware they charged him, Judge.
Okay, so you're okay just having him no bond until his Arthur hearing, right?
Yeah, the Arthur hearing's already set.
Yes, I know. Okay. All right.
Thanks for calling.
Okay. All right. Bye.
Bye.
Okay. So that's what we'll do.
And you are going to find PC to
Yeah,
the
I did
additional
find
counsel.
PC.
Thank you, Your Honor.
Okay, so he has his court hearing set in a few months, next month.
So he can't set a bond today? He
Right,
can't set a
right,
bond today?
right. And his attorney is well aware and understands what's going on. He'll talk to you about it.
Okay, thank you.
Okay, good luck. Right. Okay, what is... This is all stays with him. All right, David Perez.
North Broward.
North Broward.
Okay, hi, Mr. Perez. How are you? How you doing?
All right. Mr. Clark, you're about
Okay,
5
so
away.
you're charged
You'll
with
be next
burglary
year, but
of an
5 away.
unoccupied dwelling. I did find probable cause, and I'm going to ask the state for their recommendation.
And Your Honor, state would be asking for $5,000 bond, and I'm pulling up the priors. Your Honor, I have a 2006 misdemeanor theft adjudication, a 2016 dealing in stolen property, withhold of adjudication, false ownership of information adjudication withheld, 2016 burglary of conveyance, 2 counts, adjudication withheld, resisting obstructing without violence in 2016 withhold, 2 counts of petty theft in 2016, 2014 possession of paraphernalia, and those are within Broward County, Your Honor.
Okay, so how long have you lived in South Florida?
Over like 20 years.
Okay, and do you have a job?
I did at the time.
Okay, and do you have family here?
Yes, ma'am.
Who do you live with?
I was living with my dad in Miami.
Okay. All right, we're going to post the bond at $5,000. Good luck to you.
Okay, thank you.
Okay, Michael Young.
Conte, Your Honor.
Conti.
Hi, sir. How are you?
Hello, good morning.
Okay, sir, you're charged with grand theft and fraud, uttering a false instrument. I found probable cause. I'm going to ask the state for your priors and their recommendation of bond.
Your Honor, state would be okay with the standard bond of $1,000 on count 1 and count 2.
All right, sir, you work here? You have ties to the community?
I've been here 50 years.
I'm sorry?
I've been living in Broward County 50 years.
Okay, and are you working?
I'm a painter, yes.
Okay, so we're going to keep the bond at $1,000 on counts 2 and 3 each. Good luck to you.
All right, thank you.
All right. Robert Clark?
Main jail.
All right, sir, how are you?
I'm doing good, ma'am.
All right, so you're charged with robbery without a firearm. I found probable cause. I'm just going to ask the state for their recommendation.
And Your Honor, this is an ad charge as well. 1 moment.
While she's looking that up, Judge, I can tell the court that he's lived here for 18 years, that he is single. He currently works at Einstein's Bagel Shop. He indicated he has a little bit of money, but not a lot in the bank. He does have family members that live here in the area as well.
Your Honor, the prior charge is a robbery with a deadly weapon, the 1st degree, and I do believe he's being held no bond on that count. I just wanted to clarify. The state would be asking for a $10,000 bond on this charge based on, in light of the facts of the case and the prior.
Okay, so he's being held already?
And I'm confirming that he's being held no bond, Your Honor. He's actually being held on a $25,000 bond, Your Honor, on count 1, and this is the ad charge of count 2, so state would be asking for a $10,000 bond on count 2.
Okay.
Judge, where does it have in the PC that there's a deadly weapon or any weapon?
No, there's no weapon. This is a second charge. This one isn't the deadly weapon charge.
Correct.
Okay, this is no firearm and no weapon.
Right.
Okay.
Judge, I would just ask that the court would consider lowering it. He's already got a $25,000 bond on count 1. I don't know if the court would consider RORing him on this count because he's got a huge bond to make on the other.
That I'm not going to do. But I'll do I'll do 10,000 on this. Thank you.
Thank you, Judge.
All right, Frederick Brown. I'm sorry.
That's North Broward, Your Honor.
Hi, Mr. Brown. How are you?
I'm okay.
All right, so is this a change of charge also?
No, Your Honor, it's actually a capias.
Capias felony, 2 capias felonies and a capias misdemeanor, and it's set at no bond for counts 1 and 2 and 500 for 3.
Correct.
So we will leave that intact, and you'll see a trial judge on the 7th, 27th to 7th, March 7th. Good luck.
Okay.
Okay.
All right, thank you.
All right. Travis Etienne?
Main jail.
Right.
Hi, sir. Good morning. Could you hear me? Okay. Good morning. All right, so you're
Morning, how you doing?
I'm good. How are you? All right, so you're charged with carrying a concealed firearm, possession of cannabis, driving with a suspended license, disobeying a traffic device, not wearing your seatbelt, and 2 counts of probation of violation. I did find probable cause. I'm going to ask the state for their recommendations.
And Judge, I would leave the standard bond on count 1, and on counts 2 and counts 3, I would have no objection to ROR. Count 4 is a traffic infraction, and so is count 5. I do believe he's being held, however, on the VOP, no bond on count 6 and count 7. I think that may be a 94806 hold.
Okay. All right, so that's what we're going to do. We're going to follow the state's recommendation, and it's not that if you can post, because you can't post. Okay, so you're going to see your trial judge March 7th? March
Tuesday.
7th. Yeah. Okay.
And I'm sorry, I missed the bonds, Judge. I'm sorry, I was
Okay,
explaining something to him.
On count 1, the $1,000 standard bond, count 2 and 3 ROR, count 4 and 5 is not applicable, and count 6 and 7, he's being held no bond pursuant to the VOP hold.
Judge,
okay.
Can we set bond at $1 on 2 and 3? Because he's no bond, so he's going to be in anyway. So you might as well get credit for the time he is in.
For the infractions?
No, for the possession of cannabis and the driving with suspended license. Just
She can't change a judge set by another judge, and the bond is $1,000 on that one, okay?
I can pay that anytime?
Yeah.
Today?
Yeah.
It's ROR. Yeah,
I would wait
just
till
leave
you
it
go to
ROR. Leave it ROR.
Okay.
All right, thanks. Russell
Thank you, Judge.
Gaskin? Thank you.
If it's ROR, then he gets no credit. If you just leave no charge.
Leave it the way it is and no charge. You'll get the credit.
Okay.
How you doing, Your Honor?
Good, how are you?
I'm good, blessed.
Okay. Sir, you're charged with possession of BVP, probation of violation, 3 counts, 4 counts of felony violation of probation. So,
Which is being held no bond on.
yeah, they're all no bond, and count 1 is possession of PVP. We'll leave that bond at 1,000. You'll see a trial judge Tuesday. Good luck.
Thank you, Judge.
All right, Desjuan Jacobs?
Main jail.
Hi, sir, how are you?
Hey, I'm okay.
All right, so you already have a bond on count 2 of $500 for a warrant. We'll leave that, and then you're also charged with grand theft. But the judge didn't set that bond, right?
That's actually a new offense in front of Your Honor to find PC for.
Yeah, I did find PC on that one.
State's okay with the standard bond, Your Honor. He
Okay,
has no known
do you
charge.
work?
No, I'm homeless and I'm kind of working through a temp service when I can.
Okay, and how long have you lived in Florida?
Just a year in February.
You have any family ties here?
No, all my family is in Ohio and Georgia.
Okay, we're going to leave the $1,000 on count 1 and the $500 on 2. You'll see your trial judge Tuesday. Good luck.
All right, thank you.
Okay. Kevin McBride?
How you doing, y'all?
Good, how are you, sir?
All right.
All right, sir, you have 3 warrants out. One's for a misdemeanor, and counts 2 and 3 are felony capiases. And those 2 are no bonds already set, and $1,000 has been set on count 1, so we're going to leave that till you get to your trial judge. Good luck. Benjamin McGraw?
He's on his way up.
Okay. Hi, sir, how are you?
All right.
Okay, so you're charged with burglary of an unoccupied structure and grand theft. I found probable cause. I'm going to ask the state for their recommendation.
Your Honor, on count one, state would be asking for a $1,000 bond as well.
Okay, and sir, how long have you lived here?
12 years.
Okay, are you working?
Yes.
Okay, and where do you work?
Ordnance thrift store.
I'm sorry?
It's a thrift store.
Okay, thrift store. Okay.
Thrift store.
All right. And do you have family down here?
No, you're not.
Okay. And priors?
Your Honor, he has a possession of alprazolam in 2012 in adjudication and a petty theft in 2016 adjudication. Those are in Florida.
Okay, we'll leave 1,000 on each count. So if you could bond out, you'll get out today. If not, you'll see a trial judge Tuesday. Good luck.
Thank you.
Okay, Curtis Plummer.
How you doing, man?
I'm good. How are you, sir?
I'm alright.
All right, sir. You're charged with permitting an unauthorized person to drive and 2 counts of probation violation for felonies, which are no bond holds. And
on count one, it's a traffic criminal $2,500 bond.
Yeah, I'll ROR on count 1. All right. Good luck to you. All right. Jacob Rock.
And Judge, on that last case, you were finding PCS to that
Yes,
count.
I found probable cause, yes.
Judge, this is also counts 1, 2, and 3 are municipal ordinance cases. I would ask that the court consider RORing them on those since nobody's here to prosecute or defend them.
I will do that, but on count 4, it's a probation violation for a felony, which is a no bond hold.
Correct.
So I do find probable cause on the other charges, and you'll see a trial judge this week. All right, good luck.
Judge, I'm so sorry.
Yes. Okay. William Cloninger. Blake Jackson.
Cloninger's here.
Oh, I thought they said bonded. Okay. All right, sir. How are you?
All right.
All right, so you're charged with burglary in an unoccupied structure, grand theft, giving false information to a law enforcement officer, and a felony capias is outstanding. So I found probable cause. And what do you want for count 1, Steve?
Judge, they would be asking for $1,000 on count 1, and he's being held no bond on count 4.
Okay, we'll leave 1,000 on count 1 and count 2, and 100 on count 3, and your no bond is going to be set, kept in place for count 4. So you'll see a trial judge on Tuesday, I guess, right?
The 13th.
The 13th. Okay. Good luck.
Okay.
Blake Jackson.
Main jail.
Hi,
Good
sir.
morning, everyone. How y'all doing?
I'm good. How are you?
I'm alright.
Okay, so you're charged with grand theft auto. I found probable cause. I'm going to ask the state if you have any priors and what they recommend for bond.
A misdemeanor resisting without violence, Your Honor, withhold of adjudication in 2012. State would be recommending the standard bond, $1,000.
Okay, you work here?
I'm sorry, Judge.
Does he work here?
No, ma'am, I don't have a job.
Okay, and how long have you been unemployed?
For like 2 weeks.
Oh, what'd you do before that?
I was with Labor Ready.
Okay, and you have family here?
Yes, ma'am.
Okay, and who do you live with?
My grandmother.
Okay. And all right, $1,000 bond. That's good.
Should we be able to sign it off? Do you want pretrial? What is that?
Judge, would you consider pretrial release for him?
I have not been able to verify his information. Just now he told the court he lived with his grandmother, told us he lived with the aunt, gave us a phone number for our father, and we haven't gotten a hold of him. I called him myself.
Yeah, well, we're good. We'll leave it. All right.
Okay, thank you, Judge.
All right, good luck. Prince Malachi Benja Johnson. Hi, sir. How are you?
Morning, Your Honor.
Good morning. Sir, you're charged with burglary and
Judge, I may
dealing
have
in
a-
stolen property?
I may have a probable cause argument on this.
I know, hold on.
You do?
Yes, I believe so, Your Honor.
Okay. And we could turn that down.
Just reviewing it now, is there anywhere in this PC where he is identified as the person actually taking the property from the home? It looks like just the car was registered in his name, but someone else obviously could have been driving that vehicle during the commission of the offense.
One moment, Your Honor. Your Honor, it seems as though the victim identified the defendant through him driving that vehicle, the Ford Taurus, with the Florida tag, which was then found to be registered to the defendant. And Your Honor, I would just argue that would be circumstantial evidence as to the fact that it was,
Yeah, that's good.
she ID'd.
Yeah, no, it's good enough. It's good enough for me. So, how long have you lived here, sir?
About 25, a little bit longer than that, about
Okay.
28 years.
All right, and you working?
My mother, yes, Dollar Tree.
Okay.
And I'm also, I'm starting a nonprofit organization in the process, but right now working at Dollar Tree.
Okay, let's see, any priors?
Yes, Your Honor. 2006 possession of cannabis, 2007 criminal mischief, 2007 possession of cannabis and paraphernalia, 2007 improper exhibition of a weapon, misdemeanor battery, robbery with no weapon in 2010, resisting without violence in 2010, possession of cannabis in 2010, trespass in 2010, another possession of cannabis in 2011, another trespass in 2016, 2016 resisting without violence, 2016 misuse of 911, 2016 resisting without violence.
Okay.
State would be recommending $5,000 on count 1 and leaving the bond at $3,500 on count 2.
Okay, so that's what we'll do.
Judge, I can tell the court, he indicated to me before, he wanted me to ask the court for a ROR, but if the court's not inclined to do that, I would just tell the court he's only got a few $100s in the bank. He wouldn't be able to afford an $8,500 bond at this point.
Okay,
I don't know if the court would
he could
consider
ask
something less than that.
Now I'm going to do 5,000 and 3,500, and he could ask his trial judge to reduce it. Thank you.
Thank you, Judge.
Shelley Smith.
On these charges.
Hi, sir. How are you?
I'm fine, Your Honor.
All right, sir. You have a lot of warrants out. You have a capias for a misdemeanor where the bond is set at $500.
I just got out.
Then you have 2 violation of probation felonies and 3 warrants, felony warrants outstanding. The bond is set at no bond by Judge Shearer, so we're going to leave it to that
I just did that.
until you get in front of
All
your
of them.
trial judge. On the 8th and the 9th, you have 2 court dates. Good luck. Wilkinson Felonor?
Judge, if I could just ask the state, and I apologize, Mr. Smith indicated that he did time on these charges. He just got out of prison for them. I don't know because it looks like there are different ones, a 2011, a 2015, and an 87 case. I don't know if the state can check to see if he was actually sentenced on these, and something didn't maybe make the...
Okay.
I'm checking
We're
right
checking
I
now.
was told by Judge here.
Judge, I just showed at least one of the VOPs, case number 15182 CF10A is still pending a violation of probation, so he would still be held on at least one no bond.
Well,
So,
did he serve time for any of the others? That's what they're saying.
okay, let me check on the other ones. I just checked the 15 case, there's a 2011 case. still pending and open for the violation of probation. I'll check the 2011, well, that was the 2011, I'll check the 87.
That's right. The 87 is a capious misdemeanor, so.
The
That's the
87,
$500 one.
yeah, the 87 case
Yeah.
has no information. It says that the second count loitering was disposed of, but there's no other information as to count one, the resisting without violence, which is a misdemeanor. And that's it. The 2015 case is still pending and opening. The 2011 one is still pending and opening. So he would still be held no bond in at least one of those
Yeah,
counts.
I understand. Thank you for checking. I
Okay.
appreciate it.
Thanks.
problem.
Good luck.
You'll have to square it out. with-
Wilkinson Felonor?
Good morning.
Good morning, sir. How are you?
Judge, I have a probable cause
Good.
argument on this.
Okay. Sir, you have charged with 2 counts of resisting an officer without violence and driving with a suspended license. Counsel is going to make an argument.
Judge, just for count one, which is resisting with violence, I don't believe the allegations in the PC make out
Well, I thought there were
with violence.
Oh, yeah.
He moves his arms and shoves the officer, but that could be a battery, and a battery in Florida is not considered a crime of violence because it's touch or strike. I don't believe that there's anything in here that would be considered violent. I would just be asking that you not find PC as to resisting with violence, find PC with resisting without violence as to count one.
And Your Honor, the PC does allege that the defendant shoved the officer, so using violence, and then there was a breach struggle between the officer and the defendant, so I would argue that you could find PC as resisting with violence, since there was contact made with the officer through the shove and touch.
Yeah, so you're charged with 1 count of resisting with violence and 1 count without violence and driving with a suspended license. I do find probable cause, and we'll ask if there's priors.
Judge, I only have a prior battery in 2014. I would recommend on count 1, a $1,000 standard bond, on count 2, a $500 bond, and on count 3, an ROR.
Okay, that's what it'll be, 1,500 in ROR. Good luck, sir. So he's still suspended. All right. This one, this is third. He'd be habitualized on the suspended license. Carl Toussaint?
You said Delman, right?
All right, sir, you have a violation of probation, a felony probation. Judge Scherer already set you at no bond, so you'll be in front of her this week.
Thank you.
Okay, good luck. Jeffrey Hugo?
Did you go there and come back?
How you doing?
Hi, sir, how are you?
Good, how are you?
I'm good, sir. You're charged with 2 counts, well, 1 count of grand theft, $20,000 to $100,000, and then 1 count of grand theft, $300 to $5,000.
Judge, if I could just see the probable cause affidavit on this one from the state.
Yes.
No probable cause.
And states, Judge, standard bond's already set. State has no objection. I see a prior traffic criminal.
Okay, so the court finds probable cause and will set your bond at $5,000 on count 1 and $1,000 on count 2. All right, good luck to you.
Judge, he did indicate to me he doesn't have that money. He does work at the Quick Mart. He has no money in the bank. He's been a lifelong resident here in South Florida. I don't know if the court would consider a lesser amount.
No, but his trial
Anything?
judge might. Thank you.
Thank you.
Felix Ortiz?
Hey, this one right here.
Okay. You ready? Okay.
We're ready, Judge.
All right, all right. Good morning, sir. How are you?
I'm fine. How are you?
I'm good. All right, sir, you're charged with possession of a controlled substance without a prescription. There's a violation of a municipal ordinance, which will ROR him on. And then
Thank you, Judge.
you have a KPS misdemeanor that the bond was set at 500, so we'll keep it on that. And I do find probable cause on counts 1 and 2. 1,000, okay, Steve?
Yes, Your Honor, no
All right.
objection.
All right, good luck to you.
Thank you, Judge.
The bond at 1,000. All right, James Capers.
Judge, can I ask a question? Just for the one before Mr. Capers, like Joseph Salvatore Sierra Mataro? It says there's no paperwork, so what happens with that case?
I don't have it.
Oh, okay. If the case has no paperwork, then what does it gets reset for the next day? Okay.
Yeah, they usually reset it for tomorrow. That's generally what happens.
Hi, Mr. Capers, how are you?
I'm doing well.
All right, so you're charged with grand theft auto and operating without a valid license. I found probable cause. You live here for how long in South Florida?
A long time. I'm alive.
Okay, and you work here?
Yes, I do.
Okay.
And Judge, based on his prior, state would be asking for an increase in bond to $3,000. He does have a 2002 burglary, which he was adjudicated on, also a grand theft auto, and a resisting without violence, all from 2002. He does have a 2012 possession of cannabis, driving while license suspended, 2011 no valid, 2003 possession of cannabis, since the allegations were that he was driving and with a stolen vehicle. Consistent with his prior, state would be asking for an increase in bond.
Okay.
Judge, I have a probable cause argument on this. For Mr. Capers, well, the first thing that's a little unusual about this is that
Sound we could get, yeah. Go ahead.
the first thing that's a little unusual is that the officer that supposedly observed all of this is not the author of the probable cause affidavit. It's another officer that says, Officer Diaz informed me of this, and Officer Diaz informed me of that, which is like really unusual. I'm not even sure that satisfies like the oath requirement for a probable cause affidavit when.
He was the backup officer.
Correct, but it doesn't look like, it doesn't appear that he actually observed anything. He just heard, this is all hearsay. That's just argument number one. But argument number two is, just driving a stolen vehicle really isn't enough for grand theft auto. There needs to be something more. What this supports is a trespass, perhaps, on a vehicle, trespass in a conveyance. However, there's nothing, because he could have purchased the vehicle, he could have loaned it from a friend. If he had no idea that the vehicle was stolen, then he's not guilty of grand theft auto.
I think that's more consistent with a motion to suppress, Your Honor, or later on for trial purposes.
You want to perfect it? Why didn't Diaz write the affidavit?
Your Honor, I know sometimes that when an officer arrives on scene, maybe a main officer, like a detective, would author the PC, or someone else will author the PC, so I don't find it unusual. If Your Honor doesn't find PC as to grand theft auto, and you want to find PC as to the trespass of a conveyance, but I do believe it is sufficient for the grand theft auto at this time. Looking up the instructions.
See, it says, see Officer Diaz's supplement for further. Do you have the supplement?
I can look if I have it. It's unlikely that I have it at this point already.
That would be a good thing to see.
Okay,
And
one
that's
moment.
why he wants us to see it.
Unfortunately, I do not have his supplement, but if Your Honor,
I'm going to give you 24 hours to perfect, and then the supplement should...
I would ask for 48 hours, Your Honor.
I meant 48, sorry.
Thank you.
Okay. All right. Thank you.
Thank you, Judge.
Okay, Constantine Davidson. Hi, sir. How are you? All right, sir. You're charged with possession of cannabis and disobeying a stop sign.
Yes, ma'am.
Okay, I found probable cause. I'm just going to ask the state for your You know, ROR okay?
Your Honor, no objection to
Okay,
ROR.
it's gonna be ROR. Okay.
What's your last name?
Jason Liebitz?
Davidson, D-A-V-I-D-S-O-N.
Gotcha, okay.
David.
Yep, gotcha, okay.
Mr.
You're
Leibitz
good.
is
Thank
at the
you.
Paul Ryan facility.
Hi, Mr. Liebitz, how are you?
All right, man.
Judge,
How
I
are
don't
you?
have any, I have a warrant, I have a capias, but it's a change, it looks like a change of charge capias. I don't have any, like a narrative or.
The battery on a public or private education employee is what you're charged with?
Yes, I have copies.
Thanks.
I'm really confused. What, this PC isn't for a battery in a public or private education employee.
And I don't,
I mean, it's robbery with a weapon and abuse of elderly. And he has an out-of-county county hold felony in Duval for $150,000. That's what's on the booking. I don't know why on this paperwork that the charge is that.
and Your Honor, I do agree. Hold on one moment. I'm just trying to see if I have any other information.
See, the comments were a change of charge from abuse to battery.
Correct. But I don't have any indication on who the victim is to make her or him a public or private education employee.
I mean, are the charges just, but the other charges, the robbery with the weapon and the out-of-county hold, they're not even on this.
Those were already dealt with prior, Your Honor.
Okay, okay.
This is the change of charge capias again. And I do believe it's for public or private education. And I don't have the information sufficient, Your Honor. I would ask for 48 hours
Okay.
to effect.
It
For
looks
effect.
like, whoever did the change of charge, they put in the wrong statute.
Yeah, I
Yeah.
think,
I'm looking to see what the correct statute is, Your Honor, and I'll give you a corrected looking to you.
Thanks. Thanks.
so it's supposed to be a battery on an individual
Yeah,
over.
so the charge is battery on a person 65 years or older.
And I do believe in the original PC that I handed, Your Honor, although the victim's name's crossed out, you do see that the individual is 65 years
Yeah,
old.
yeah, okay. So you have a copy of this, counsel?
I have a copy of the
Okay.
Is there touching?
Yeah. Struck him several times in the face, allegedly. So I do find probable cause, and I'm just, priors.
Your Honor, there's a prior traffic criminal leaving the scene in 2014, a prior possession of controlled substance in 2002, but those are only within Broward County. However, on count one, there's a $150,000 bond. On count two, state would be recommending a $5,000 bond.
Okay. All right, we're gonna do that. We're gonna do a $5,000 bond on count two. Good luck. All right, Mitchell Williams?
Conti.
Hi, Mr. Williams, how are you?
All right.
All right, you're charged with a felony battery. And I did, is there an ad charge on this?
Yes, Your Honor, it looks like.
And Judge Cohn ordered no bond?
Judge, he would be entitled to bond. This is a bondable offense.
Okay.
There is a PC attached. I think it's based on the prior, Your Honor, with the prior conviction and. A moment.
So what are you recommending, State? I do find probable cause.
Your Honor, state would be recommending a $2,500 bond based on the allegations in the warrant, and he does have a prior battery where he was adjudicated in 2009.
Judge, could we ask him what his connections are to the community? Mr. Williams, can you hear me?
Yeah.
How long you lived in South Florida for?
All my life.
And do you have a job?
Yes.
Where do you work?
At Harmsco. I'm a welder.
Okay. Do you have any family in South Florida?
Yes. All of my family stay in South Florida.
Okay. Do you have any kids?
I have 2.
Okay. And do you have any savings?
No.
Okay. Do you own any property?
No.
Do you have a place to live?
Yes.
Okay. What type of place? Is it a house, apartment?
Apartment.
Okay. And who do you live with?
A cousin.
All right. Judge, he's got substantial ties to the community. Doesn't appear he has any savings. He has a trade. Asking for $1,000 rather than $5,000.
Yes, Your Honor.
Okay, 3,500 bond.
And I would ask for no victim
And no
contact.
victim contact. Good luck to you. Okay, we're on the case of Kevin Nelson.
Main judge.
All right, sir, how are you?
Blessed and highly favored. How about yourself?
I'm good, thank you. Sir, you're charged with 2 counts of premeditated murder. I do find probable cause, and I'm going to,
Judge, is there does he have another case? We can sort of maybe set this on the same date with the other case.
I don't know.
Does he have like a court date or something that's set?
He has a court date, but I don't know if he has another case.
Judge, who are we addressing? I just want to make sure.
Kevin Nelson.
Kevin, okay, my apologies. Your Honor, there was a grand jury indictment as to a true bill on the 2 counts of murder, so he is to be held no bond.
Right.
And I believe there was a Nelson. Never mind.
So there isn't another case?
No, it's just other counts.
Okay. All right, so these are no bond hold charges. So you're going to be in front of your trial judge within a week?
When's the next
You
court
have the
date,
court
Madam
date?
Clerk? Oh.
Okay. All right. Counsel will get you your next court date. Okay?
But, The public defender's office actually has been appointed on it. He's spoken to Melissa McNeil, who's one of the attorneys in our office that handles these cases. So
Okay.
I would imagine that they'll set an arraignment probably next week or so.
Yeah.
But I will email her today and let her know.
Okay, so these are no bond charges, so you're going to be in jail until you get to your trial, Judge.
Thank you, Your Honor.
March 8th, the clerk just told me. Thank you. Good luck.
I think Wednesday.
Thank you, Judge.
Okay, thank you. Calvin Wilson?
That's North Broward, Your Honor.
All right, sir, how are you?
I'm good.
All right, sir, you're charged with aggravated assault with a deadly weapon. I did find probable cause, and I'm going to ask the state for priors.
Your Honor, I have an ag assault, 2 counts of ag assault from 2007 and juvenile priors. The state would be recommending a $1,000 bond on this count.
1,000?
Yes, Your Honor, with no victim contact. I do believe he's already received a bond on the other count.
I'm sorry, who are we on?
Calvin Wilson. I'm sorry, what were the priors?
Just two counts of aggravated assault from 2007, and he does have juvenile priors.
All right, I'll make it 2,500, no victim contact. All right, good luck to you, sir. Sean Toth.
North Broward.
You have his record, his driving record.
The last guy on the docket.
All right, so you're charged with driving with a suspended license. I just need to see.
I can look it up, Your Honor.
Okay. We're just going to look up your record, because if you plea your case out and it's your 3rd time, you could lose your license for 5 years. Oh, it's a felony one. Okay.
Oh, this is a 3rd or subsequent offense.
Okay, so is he driving on he was habitualized on this? I don't have his record.
I'm trying to pull it up.
Judge, I'd be asking that Your Honor not find PC because the probable cause affidavit doesn't allege that he has a driver's license. Ms. Camille Smith may be familiar with this argument.
Your Honor, there's some legal issues with whether or not an individual can be charged with a felony driving while license offense when they've never owned a driver's license, but I am looking at his driving record, and I'll print out a copy for you and counsel. He was previously issued a driver's license in the state of Florida, and I do see that he has been habitualized, and those habitualizations were based on prior driving while license suspended, one from 2008, one from 2009, and one from 2010. If I may approach.
Thanks. Thanks. Well, yeah, and it's revoked, so. All right, so what do you want the bond to be?
Your Honor, the standard bond, that's set $750.
Judge, if we could just look at his driving record, maybe just ask him a few questions.
I do find probable cause. Oh, I was going to give you mine, but that's okay.
Judge, I just looking at his driving record, a lot of these suspensions appear from failing to pay for his traffic tickets. So it doesn't appear he has very much money.
I don't.
Sir, do you have a job?
I do have a job, sir.
What do you do for a living?
I install screen and impact windows.
Okay. And do you have a place to live?
I live with my mother, yes.
Okay. And do you have any, other than your mother, any family in South Florida?
All my family lives here, and I also take care of a 5-year-old little girl I do by myself.
Okay. And do you own any property?
I have no properties.
And how long have you lived in South Florida for?
All my life, 36 years.
Okay.
Okay, we'll leave the bond at...
It's $750, Your Honor.
Okay, good luck to you, sir.
Thank you.
All right, Mark Trushan.
Yeah, he's a medical reset, Your Honor.
Okay.
He's been out all week. He's in. No, I can't tell you on this,
Okay.
but yeah, he's
All
sick.
right. Kendrick
All right,
Perry.
you have a good weekend.
You too. Where's Kendrick Perry? And where's the
Angel.
Okay. All right, sir. How are you?
I'm all right, and you?
All right, I'm good. See, we saved the best for last here. You, sir, you're charged with possession with intent to sell, riding without hands on your handlebar, and you have a writ of arrest out for you. So I did find probable cause. You okay with ROR?
Your Honor, he does have some priors: delivery of cocaine in 2002, trespass in 2002, possession of cannabis and trespass in 2003, resisting without violence 2004, possession of cannabis 2005, delivery of cocaine 2007, one count of possession of cocaine and one count of possession of cannabis in 2014. So I'd object to a ROR and
Got a pretrial release.
no objection to ROR with pretrial release.
You know.
Oh,
I have
So-
no charge in 14.
he may not be eligible
Okay.
for pretrial. I would maintain the $1,000 standard
Okay.
bond.
Judge, I would ask for this reason that drug charges, and I'm sure the court's aware that the drug charges, the lab's been shut down 2 years ago. They run like 90 days behind or so filing charges. Most of these people get out within 30 days because the state has 33 days to file. If they don't, we usually get them out. So rather than have them sit in jail for 30 days and then be able to get out, I would just ask the court if the court would consider RORing him now. He does have to pay that $321.
Yeah,
to bond.
I'll ROR him with pretrial release. And he does have to pay the $321, and count 2 doesn't affect.
That's fine, Judge. He would appreciate that.
Okay. All right.
Thank you. Thank you, Judge.
Everyone. See you tomorrow.
All right.
Okay, thanks.
Thank you, Judge.
Thank-
We're off, right? We're off the record?